Welcome viewers to yet another important discussion on the Customs and GST Advisory channel of Customs, gs.com. Those who have watched our earlier video on customs classification will recall one fundamental proposition we discussed. An imported product cannot ordinarily be classified merely on the basis of where the importer ultimately intends to use it. But an important question remained. Does that mean use is never relevant? Can a product specially designed for one industry still be classified without considering its intended function? And where common parlance, trade parlance, HSN Explanatory Notes, and the general rules of interpretation fit into this exercise, the Supreme Court has now provided a remarkably detailed answer in Commissioner of Customs, Import versus Welkin Foods, reported as 2026 in INSC 19. So consider today's video as the next chapter of our earlier discussion. We are no longer asking simply, does end use determine classification? We are asking the more precise question, when is use legally relevant to classification, and when is it legally irrelevant? The significance of Welkin Foods is that the Supreme Court does not merely repeat the old proposition that end use cannot control classification. It constructs a hierarchy of classification. First comes the tariff heading itself, then the section notes and chapter notes, then the HSN framework and applicable explanatory notes, then, only where necessary, principles such as common or trade parlance, and only where the relevant tariff language permits it does, use enter the classification inquiry. This is why the judgment should be seen as an important refinement of the traditional end-use doctrine. The court expressly says that the GIR are binding and must be applied sequentially, with GIR 1 forming the foundation of classification. Let us understand this through the actual dispute. Welkin Foods imported aluminium shelving for mushroom cultivation, along with a floor drain and an automatic watering system. The importer treated the shelving as a part of agricultural machinery under Tariff Item 8436.99.0. Customs said, not allowed at the point of import. What has entered India is essentially an aluminium structure, classifiable under Tariff Item 7610.9010. Sestat accepted the importer's case substantially because the shelving was specifically designed for mushroom cultivation, was intended to integrate with other equipment, and was known commercially as a mushroom growing rack. The Supreme Court reversed that approach. Here we must refine something extremely important. When we say end use is irrelevant, that expression can become too broad. Welkin Foods draws a distinction between actual use and intended use. Actual use means what happens to the goods after importation. That ordinarily cannot determine classification because the taxable event occurs when the goods are imported. Classification therefore follows the goods in their condition as imported. But intended use is different. The Supreme Court says intended use may be relevant where the tariff heading itself refers to use or adaptation, either expressly or inherently. Therefore, the correct proposition is not, use is never relevant. The correct proposition after Welkin Foods is, actual subsequent use ordinarily cannot determine classification. Intended use may be considered only where the tariff structure makes use relevant. The court then adds a second safeguard. Such intended use must be inherent in and discernible from the objective characteristics and properties of the goods. This distinction gives us a much better legal test. Suppose an importer says, this product will be used in agriculture. That statement by itself proves very little. The question is not merely the importer's intention. The question is whether the product's design, construction, composition, function, and objective characteristics demonstrate the intended use required by the tariff heading. The Supreme Court deliberately prefers objective characteristics because customs classification must be verifiable at the border. Private intention cannot become the governing classification test. The judgment says reliance on objective characteristics promotes legal certainty and avoids subjective elements being used to manipulate lower duty classification. The next major clarification deserves special attention. Sestet approached the case on the footing that Chapter 76 was the general category of aluminium structures, while Chapter 84 was the more specific category relating to agricultural machinery. That sounds attractive. But there is a methodological problem. This specific versus general principle arises under GIR 3 and GIR 3 does not become available merely because two descriptions appear attractive. The Supreme Court says classification begins with GIR 1. GIR 3 is invoked only when the proper application of the earlier rules actually leaves the goods prima facie classifiable under two or more competing headings. So the lesson is, do not jump to the specific over general rule before first determining the scope of each heading under GIR 1. The court described non-sequential application of the GIR as an error that must be avoided. In our earlier classification discussions, we have also referred to common parlance and trade parlance. Welkin Foods tells us precisely where that test belongs. Common parlance is not the first test in a HSN classification dispute. It operates primarily where statutory guidance runs out. If the tariff heading, section notes, chapter notes, or HSN framework already provide the answer, market terminology cannot override the statutory structure. The court's proposition is therefore extremely useful. Common parlance fills statutory silence. It cannot displace statutory guidance. Paragraphs 148 and 149 of the judgment make clear, GIR 1 and the statutory. Now apply those principles to Welkin Foods. Customs Tariff Heading 8436 deals with agricultural machinery. The expression itself contains two components, machinery and agricultural use. The Supreme Court said you cannot concentrate on the second component and ignore the first. Before asking whether the product is principally used in agriculture, you must first establish that the product answers the identity of machinery. That gives us another powerful classification rule. Where a heading combines product identity with use, both conditions must be satisfied. Something does not become agricultural machinery merely because it has been designed to operate inside an agricultural facility. The court treated heading 8436 as an EO nomen, or by that name, heading for agricultural machinery whose wording inherently involves principal agricultural use, but still required the product first to answer the description of machinery. The importer also relied on Section Note 5 of Section 16, which uses the expression machine to include machinery, plant, equipment, apparatus, and appliance for purposes of those notes. That definition operates for the purposes of the section notes. It does not allow courts to rewrite the individual tariff heading. If heading 8436 says machinery, the word cannot simply be expanded into every possible plant or installation by using Section Note 5. This is another classic lesson in customs classification. A section note assists interpretation. It cannot be used to insert words into the tariff heading that Parliament did not put there. Another extremely useful part of Welkin Foods concerns functional units and composite machines. The mushroom growing installation contained several machines. There was head-filling equipment. There was an automatic watering system. There was compost spreading equipment. They all participated in mushroom cultivation, but the Supreme Court said that was not enough. They were not shown to be permanently fitted together as one composite machine, nor did they combine to perform one single clearly defined mechanical function. Each performed its own independent task. Their common link was only the wider commercial process of growing mushrooms. And that produces another useful rule. A common business objective is not necessarily a common tariff function. The judgment consequently rejected classification of the overall mushroom growing arrangement as a composite machine or functional unit under heading 8436. And now, perhaps, the most quotable principle in the judgment. The aluminium shelves physically supported the machinery. Equipment was installed upon them. They were commercially important to the mushroom growing arrangement. But did that make the shelves a part of the machines? The Supreme Court said, not the part of machines. The individual machines were already complete and operational. Their electrical and mechanical functions did not depend upon the shelves. The shelves simply provided a surface upon which those devices could operate. The court expressed this distinction in remarkably simple language. A surface supports an object, but does not become a part of it. That statement has implications far beyond mushroom cultivation. Think of support frames, platforms, racks, mounting structures, foundations, skids, and structural assemblies used throughout industrial plants. Physical support or commercial necessity does not automatically transform a structure into a tariff part of the machine. The Supreme Court ultimately held that the aluminium shelving satisfied the characteristics of an aluminium structure to enter Tariff Item 84369900. Two conditions were necessary. First, there had to be agricultural machinery, and second, the shelves had to qualify as parts of that machinery. Neither condition was satisfied. The mushroom growing arrangement itself did not qualify as machinery under heading 8436 in the manor claim, and the shelves were not parts of the independent machines mounted upon them. The Supreme Court therefore restored classification under CTI 76-10-90-10, aluminium structures, and set aside the Sestet decision. So how does today's judgment connect with our earlier video? The earlier discussion gave us the basic caution. Do not classify goods merely by their ultimate destination or end use. Welkin Foods now gives us the complete methodology. The Supreme Court effectively says, first, identify the goods as imported. Second, start with GIR 1/3. Read the tariff heading with the section notes and chapter notes. Fourth, use HSN Explanatory Notes where applicable. Fifth, resort to common parlance only where statutory guidance is insufficient. Sixth, ask whether the tariff legally permits consideration of use. Seventh, distinguish actual use from intended use. Eighth, if intended use is relevant, establish it from objective characteristics. Ninth, where classification as a part is claimed, prove an actual functional relationship with the machine, and only thereafter move to subsequent GIR if the classification still remains unresolved. So the earlier principle has not been displaced. It has been refined and structured by the Supreme Court. If I had to reduce Welkin Foods to one formula, it would be this: classification equal legal identity first. Use only where the tariff makes use relevant. And where use is relevant, intended use must emerge objectively from the goods themselves, not merely from what happens to them after importation. That distinction should now become the starting point whenever customs or an importer seeks classification based upon end use. The court's formal conclusion states both elements together. GIR must be applied sequentially, and only intended use objectively discernible from the goods may be considered where the heading expressly or inherently makes use relevant. So if you have already watched our earlier discussion on end use and customs classification, Welkin Foods should be viewed as its judicial sequel. The Supreme Court has now supplied the more complete answer. Not actual end use by itself. Intended use may matter, but only within the limits written into the tariff, and only when objectively reflected in the imported goods. That is the difference between classification by commercial destination and classification by law. If you found this analysis useful, I strongly recommend watching our earlier video together with this one, because the two discussions complement each other. Like, share, and subscribe to Customs and GST Advisory for detailed discussions on customs, GST, and indirect tax litigation. Thanks for watching this video. Visit customsgas.com for further advice and guidance. Know the law, understand the principle, protect your rights.